Good morning, everybody. I'm Greg Riley. I'm with Schoeneck King, and I'm joined today with Sarah Luke.
Hi, everyone.
Hey, Sarah. Who's one of our Cracker Jack attorneys. We're here to speak with the automobile dealership industry here in New York about what's going on, the most recent developments with respect to COVID-19, and in particular how they apply to employment law issues. To kind of give you a quick overview of what we're going to be discussing today, we're going to review the recent executive orders by Governor Cuomo. Then we're going to talk about the new state sick leave law. And then we're going to talk about the federal law that came out. And then before this webinar began, we got a bunch of questions that people are interested in from your group. So we're going to address those questions. So that's what we're up to this morning, and I hope you find this helpful. Okay. Let me blow this up a little bit here. I think that should do it. Okay. So first thing, we're going to talk about 3 executive orders. The first one is 202.5. It's a simple order. It doesn't have immediate effect on your industry necessarily, but basically Governor Cuomo is taking this really seriously. So he's closed a bunch of things that are listed on this this slide: indoor shopping malls, aquariums, zoos, what have you, places where people congregate in a confined space. Of course, then with that thinking, it doesn't apply to public parks and open recreation areas. If there's a theme to these executive orders, it's social distancing. So 202.5, the first executive order, really kind of sets the tone for the rest of them. The next executive order, and this does apply, was issued only on Wednesday, March 18th, and it basically requires social distancing in the workplace. So it states that each employer's got to reduce their in-person workforce at any of its work locations by 50% no later than today at 8 p.m. So that's an issue. How do you get your people that are showing up to your place of business? Who you decide is going to be there and who's not? We'll talk about that. Now that executive order, which has the force of law, says that some businesses are exempt, and you're exempt if you're quote unquote essential. And the question, so what's essential? They're kind of things you think about. Healthcare institutions like hospitals, the financial industry, police and fire, the defense industry. So there's a bunch of essential industries that are exempt. And of course, for automobile dealerships, we'll get into that. Some parts of them are, and some are not essential under the executive order. The other thing is the executive order says that this Empire State Development Corporation is going to decide on a case-by-case basis, if necessary, what's essential and what businesses are essential and what are not. If your business is not deemed essential, you can apply for an opinion asking that it be made essential, or if it's unclear whether you're essential, you can get an opinion. And there's a form that you fill out to do so online, and you can fill it out yourself. We'd be happy to help you if you have any questions on that. But it's a very broad order. It applies to all businesses, both profit and non-for-profit in the state. And it requires you, as I said, to cut your in-person work staff down to 50%. But they're asking as well in the executive order, so if you can cut it down more, great. So some employers are doing that, complying with this by having people work at home using computers or what have you, just kind of like what we're doing today. So that was on Wednesday. They issued this 50% in-person restriction. You can't have more than 50% of your people in the office or at your work facility at any given time, unless you're a essential industry. The next day, another executive order was issued. This one was 202.7, which says, you know what? We're going to change the percentage. We're going to make it now 75% of your workforce has to be reduced at the premises. So only 25% of your non-essential people should be there. Otherwise, they should be either working from home or laid off or on furlough, or there are other options as well. But you have to, it's social distancing. You really do have to reduce the number of people that are confined at your workplace or in one space. This new rule, moving from 50% to 75%, has to be implemented no later than 8 p.m. today. So starting basically tomorrow, or after 8 p.m. today, you shouldn't have at a non-essential industry workers there at your facility that exceed 25% of your regular workforce. Okay, so how does this affect your industry, the auto dealership group? Well, luckily there's been some guidance on this already. To start, the guidance was issued yesterday, and it says it interprets essential services to mean those lines and or business operations that are necessary to support the essential services. Like I said, the essential services have been defined as healthcare, police, a bunch of different industries, and there's guidance on that, which we can forward to if you wish. But as far as your area, automobile repair is defined in the guidance as an essential service. That's a good thing. Your automobile repair shop, and you think about it, it makes sense. Your automobile repair shop can stay open with a full complement of automobile repairmen. You just want to obviously keep them separated, the mechanics separated to the extent you can, but they're permitted to work. And why are they considered essential? I think probably because they're people that are fixing people's cars that they need to go to do childcare or go to the hospital and work as a nurse or a doctor, or they're police or fire. So the guidance made clear that auto repair is an essential service. The question, of course, is, well, what about all the other people in the dealership? Because in these auto dealerships, as you all know, you have salespeople, you have clerks that are picking up the payments. You have janitorial staff. You have all different other kinds of workers. Well, the guidance gives you some assistance with that as well. So the guidance says you should be able to maintain 100% of your automobile repair employees that are providing these in-person services, but you're limited to 25% of the non-essential dealership employees. Okay, let me give you a quick real-life example. I'm not a mathematician, so I'm going to make it really simple for me. Let's say you had 125 people working at your automobile dealership, and 25 of them are in the repair shop. Well, those 25 can stay working there and come to work and be on your premises. However, the remaining 100, you're only permitted to have 25 of those remaining 100, or 25% of those remaining 100 on premises at any given time during that workday. What are you going to do with the rest of them? Well, that's something that's going to be a hard call. In some cases, maybe they could work from home. In some cases, maybe you could rotate them out, you know, so some days some people work on a Monday, other people work on a Tuesday. Unfortunately, you may have to lay off some because they're not working there. As I'm sure you're kind of thinking this through, people get their car repaired in the shop, and you're going to need people to collect the money for those repairs. You're also going to need people to schedule the repairs. So some of those people support the essential service of repair. You're probably going to want to focus on those people in implementing the executive order and consistent with the guidance. I'm going to now turn it over to Sarah. Sarah, by the way, is there anything that you think I should add, or something that any other insight you might have?
I think you've done a great job, Greg.
Thank you.
I do think it's good to point out the fact that you know, these executive orders have been coming out just on a daily basis. In fact, Greg and I worked together this morning to update this presentation because of changes to the law. So we're on top of it. We're doing our best to make sure that our clients have access to current information. And just given the nature of this situation, it's kind of, you know, a moving target. And we understand that that creates some anxiety, but we're pretty comfortable that we understand the public policy behind these EOs, and we're, you know, very happy to provide any guidance that we can as things develop. And one of the things that has developed recently is that New York State has adopted a new paid sick leave law in response to this pandemic, and it applies to all employers in New York State, but with respect to private sector employers like auto dealerships, the way that it applies will depend on the size of the employer. So when we talk about size of the employer, the law looks to how many people you employed on January 1 of this year. So for employers that employed from 0 to 10 employees, and last year made less than $1 million, there is no paid sick leave requirement under this law. With respect to employers of that size, or employers who employed up to 99 employees, so if you're really small, 0 to 10, and you made over $1 million last year, or if you are, regardless of your income last year, if you had 11 to 99 employees as of January 1, then the paid leave requirement is 5 days. And for larger employers, it's 14 days of paid sick leave. Now, it's important to note that this is sick leave pursuant to a mandatory or precautionary order of quarantine or isolation. And that determination is made by the state public health official or a local public health authority. So if you have employees that are going home because they themselves feel like they're sick, that's good that they're doing that, because you don't want them to infect other people, but this law wouldn't apply to them. Now, maybe your policies or some of the other provisions that we're going to go through later in the presentation would, but this law really applies to just a very narrow and limited scope of employees. And it provides the same types of protections that you would expect from any type of leave law. So employees have reinstatement rights, and we can't retaliate against them if they're quarantined and they avail themselves of this benefit. It doesn't apply to people who are asymptomatic. So now in the tri-state area, we are seeing that sometimes people are able to get testing, and they might be quarantined, but they might be able to do their jobs. They might have jobs like Greg and I, where they can do their jobs at home and they actually feel absolutely fine. And in those cases, it's reasonable to expect them to work, because the paid sick leave is really meant for people who can't work because they are sick. The other thing to note about this law is for people who, for vacation or recreational travel, visited countries that the CDC has considered level 3 threat. So those are places where there's really a lot of active cases, and travel is not recommended. If people have gone to those places of their own accord and they got sick that way, then they're also not entitled to this benefit. Greg, is there anything that you wanted to add with respect to the state law provisions?
No, I would just say there haven't been that many people, if I'm aware of, that have been quarantined. So right now, it sounds like a good law, but it hasn't really helped that many people yet because not that many people have been given a quarantine or isolation order. The other thing is I note that this law is in effect now. It's in effect immediately, as was the executive orders we talked about before. Well, at least the executive order about the 25% comes into effect starting 8 p.m. tonight. So, okay. Thank you, Sarah. So we had executive orders from Cuomo. We have a new state law that the legislature passed and Cuomo signed. There's also stuff going on in the federal level, which I'm confident most of you heard about, but we'll cover it. And the federal developments are twofold. I'm going to address the first one, and Sarah's going to talk about the other one. But the first one is the federal emergency FMLA expansion. If you have 50 or more employees, you're covered by this FMLA. And that law has been in effect for many, many years. But this federal law amends the FMLA and expands some of the protection. And in one area, it says, and it covers private sector's employers with less than 500 employees, and private and public sector employers, with less than 500 employees. So that's a difference. Like I said, the old FMLA, you needed 50 or more employees. This one applies if you have less than 500 employees, this federal FMLA expansion. And what does it provide? It provides protected FMLA leave if you're unable to work or telework due to the need to care for a son or a daughter under age 18, if that child's school was closed, or if your son or daughter's paid childcare provider is not available due to COVID-19. So it's a very narrow law in some respects, to the extent that it won't apply if you could telecommute, won't apply if you don't have kids. On the other hand, it's very expansive in that you don't need that many employees to be covered, and it's expansive because a lot of people who do have kids could be covered by this law. But you have to have been working there at least 30 days, not the 12 months and 1,250 hours that you'd need normally under the FMLA. So as long as you've been working there for 30 days, you're going to be covered by this law, and you're going to be entitled to the leave. Moving on here. Oh, got this little thing. Let me move it. The law is a little different than the FMLA too. This expansion part is a little different because it must be paid leave after the first 10 days of unpaid leave. You can substitute other leave benefits if you have them during that time frame. And there's different rules about how much you have to be paid under this paid FMLA expansion. Just like the state law, there's reinstatement rights. The question is, we're getting a lot of questions, well, who's going to pay for this? Well, you are. That's the responsibility of the employer as the law is currently written. However, they have in the law that you can get a quarterly tax credit to offset payments that might have to be made under the law. The law says that it's going to be effective early April 2020. We think, based on our calculations, it's going to be April 2nd, 2020. I turn it over now to Sarah, unless Sarah, you have something else to say about it, but that's I'm going to turn it over to Sarah for the other part of the federal law.
Great, thank you, Greg. So I think you probably have noticed that under this FMLA expansion, paid leave starts after the first 10 days of leave, and that might trigger a memory. Remember that state law that applies just to people who are under mandatory quarantines, well, that could come into play for that first 10-day period if an employee is quarantined. In addition to that, under federal law, for employers that are fewer than 500 employees, there is this immediate eligibility for emergency paid sick leave. And the reasons for eligibility under this provision are a lot more expansive than state law. And so we provided them in the slides for ease of reference. So it does cover mandatory quarantines and isolation, just like the state law. If an employee is seeking diagnosis, if an employee is caring for another individual who is subject to the quarantine or isolation, caring for an eligible son or daughter, or experiencing any other substantially similar condition. And you might ask, well, you know, how does that, if an employee is quarantined during those first 10 days, how do we decide what applies? Is it the state law? Is it the federal law? Well, we look at what they would be eligible for under each law. So remember, with respect to the state law, it's going to depend on how big you were on January 1 of this year, what benefits an employee would be eligible for pursuant to that. And on this slide, we explain how you would figure out the eligibility for benefits for those first 2 weeks under federal law. And so we look at both of those, and the employee is entitled to whatever leave benefit is more generous. They're immediately eligible, so this makes it different from what we're used to do with respect to regular FMLA. We can't require them to use other PTO before they use this. And as Greg explained earlier, this again, the responsibility for this benefit lies with the employer, although I do believe that within the legislation, there are tax credits included to offset some of the employer responsibility.
Okay. I had a quick observation, maybe just to kind of round it out. So the federal law basically has two parts. One part is if your kid can't go to school or your caregiver isn't available and you have to go and help your kid. Well, there you get the FMLA expansion. And the part Sarah just spoke about is if you're sick or you're subject to a quarantine order, and it provides different benefits. So we have to keep those things in mind. And then there's the interplay, as Sarah said, there's the interplay with the state law. So it's fairly complex, and different situations may apply or not apply depending on the circumstances. What I think is interesting is what isn't done. What isn't done is a lot of people are losing their jobs because of the virus. Employers are having trouble keeping their staff up because customers aren't coming to your dealership as much as they used to, I'm sure. So a lot of employers, and I suspect in your industry as well, they're laying off people. The law does not, these laws we all been talking about, do not do anything to help you in that respect. If you lose your job because of the virus, that doesn't help. All you have is unemployment that's available, at least at this time. So what does that look like? Well, I think the legislatures and the governor recognized that, hey, we got a hole here. The people could get laid off. So what they did is they modified the unemployment insurance benefits so that you don't have the 1 week waiting period in order to get the benefits. You're eligible immediately. Again, you got to wonder, and I don't know how it's going to work because a lot of people are probably applying for unemployment right now. Hopefully the state can process all of those claims. Ultimately, the unemployment decision rests with the New York State Department of Labor, the unemployment division. But so you can't represent to employees that they're going to get the benefit, but most likely they will in these circumstances. Again, don't make promises though. Let's see if I can move this screen along here. Sarah, and unless you have something else to add to that, Sarah?
No, I think that sums up where we are in terms of employees who are laid off.
Yeah, yeah. So we had a question here. Sarah's going to take it. What to do with sick or infected employees?
Yeah. So this is a question that comes up quite frequently, as you can imagine, as everyone's trying to practice social distancing, but still trying to run our businesses. If an employee is sick or infected, because we are currently experiencing a pandemic, the rules are a little bit different. You are allowed to ask people, like, hey, Sarah, you don't look so good. And you are allowed to, ask people about that. And if you do think people are sick in the workplace, you can send them home. And that's something, we usually would caution employers against doing that for concerns under the Americans with Disabilities Act, but the rules are different here because of the uniqueness of the situation. Now that also raises the question, once we've sent people home, maybe after a week or so, they say, I feel better, I want to come back to work. In a normal world, I would advise clients that it's appropriate to ask them to be cleared by their physician because you want to make sure that they're not contagious. Unfortunately, right now with the how overwhelmed our healthcare workers are with just dealing with sick people, it's going to be really difficult for an employee, even if they are well, to get any documentation from their physician. So what the CDC has recommended, that's why if you watch the news, you hear a lot about the 14 days. They do believe that on average, if someone is sick with COVID-19, that's enough time for them to both get better and not be contagious anymore. Another rule of thumb that they suggest is if a person has been fever-free for 2 days. So there is a bit of a judgment call here, but the problem with asking employees to get a fitness for work evaluation or a return to work documentation from their physician is that even if they are well, they just might not be able to have access to a physician to give them that kind of documentation. So that's sort of how we're helping employers navigate through that. Greg, did you have anything that you wanted to add to that analysis?
Yeah, as far as infected employees, if you had an employee that reports to you, let's say they call you from home and they say, oh, I just got tested and I am infected with the COVID-19. What do you do? Well, first of all, they have reported it to the Department of Health. So that's good. That would have gotten reported. But what do you tell what do you tell the person's coworkers? What you should do is, one, you should ask the employee, do you mind if we tell your coworkers? They may or may not mind. If they don't, I think you're obliged to, both maybe as a legal matter, but certainly as a moral matter, to tell them. And they may have to be sent home or because of their contact. That's a judgment call. But the other thing is, if they say, oh, I don't want you to tell people, well, you don't want to necessarily reveal their name, but you could go to your staff and say, look, we had somebody working here got an infection with the COVID-19. You should get checked out, and we thought you should know that. And that's the essential difficulty, I think, with these situations, because if it's a worker may have had contact with 10, 15, 20 people, you may end up with 10, 15, 20 people that end up going home and are going to be isolated at home for 14 days. So this is I think a real challenge for employers, but I think you got to try to do the right thing. Does that sound right to you, Sarah?
Yeah, I think that's right.
Yeah. So anyway, that's what to do with sick or infected employees. See if I can move this along. What about if you got unionized employees? Are your obligations any different? Well, in some ways they could be. First of all, my observation about the automobile dealership industry is that it's for the most part not unionized. However, to the extent there's union involvement, it's usually in the repair shop. And so this could be an issue for some of your employees, particularly in repairs, I would think. And so what if you have to lay off someone in the union shop because lack of work as a result of business being down? What if you need to ask a union employee in the office not to come in because of the Governor Cuomo's order? How do you handle these things? Well, you got to try to handle them in the way you usually do. One is when you have a union. One is that you should talk to the union folks and explain the situation, whatever it is. Two, you got to look to your contract, your union collective bargaining agreement. What, in particular, I would point you to provisions about terminations and layoffs and management rights. You may have a duty. You may not have a duty to bargain about a decision to terminate in these circumstances, because you may not have a choice as a business matter. So that's usually within the management rights to, whether to even keep your shop open, or if you have to let people go because of financial reasons, that management rights clause usually helps you there. But if there's an issue about the effects of the terminations or the effects of the changed work rules, you may have a duty to bargain about that, likely will. So those are things to think about if you've got union folks in your shop or in your store. Oh, one other thing to just go back on this. We got a question by email before we did the presentation. Someone asked, if we do have to lay off people, how do we do it? Should we do it based on seniority or not? Well, with non-union people, you don't have to do it based on seniority. You certainly don't want to do it in a discriminatory way. You want to make the best call you can. Some jobs may be more important to your facility than others, and that's pretty straightforward from a non-union standpoint. With the union employee, a lot of times layoff or termination provisions for reasons of financial distress, it's done by seniority. So I just throw that out there as another factor to consider. What do you do if you need to lay off employees? That's kind of a little bit what we already were talking about. But I've been, unfortunately, and it's depressing in a way, I think we're all going to pull through this, but I've been getting a lot of calls from clients that are saying, I've got to lay off people. What should I do? Well, you're not prohibited from laying off people under any of these laws. And if you have to, you have to. It may be the best course, if you think you have to do it sooner rather than later. The sooner they get the unemployment application in, the sooner they may be eligible for and receive unemployment. The other thing is, what I'm advising employers to do is two things actually that are required by New York law. One is you're supposed to give them a copy of the unemployment form so they know where to go to get to apply for benefits. Doesn't say, the form doesn't mean that you think they're eligible for benefits or that you're promising benefits. It just gives them directions how to apply for benefits. And then the second thing is you should give them a short letter or an email explaining when the last day of their employment ends, or when the last day of employment is, and then when their benefits end, which is actually a legal requirement in New York. So those are the two things you'd have to do if you need to lay off employees. And of course, as always, when you lay off people, you want to do it in the most respectful and kind manner. Why? Because that's the right thing to do. But also, this crisis will end, and you're going to need people, especially if they're good people. You want them to come back. So how you act now could affect your business in the future. So I think this one's yours, unless you have something to add, Sarah.
No. I think layoffs are a difficult topic to discuss, but I think you've hit all of the main considerations for people to mull through if that's a decision that they have to make. Now, generally, if an employee is sick or they are quarantined, they're not going to tell you, I would like to exercise my rights under this law, and get these types of benefits. And so really, what we've kind of done is just highlighted considerations that an employer will have to make. So if an employee is out sick, first you want to know, is the employee out pursuant to a state mandated isolation or quarantine order? If not, then you know that the New York State leave law wouldn't apply. You probably have your own sick leave provisions in your employee handbook, and so you're going to want to follow your own handbook. But with respect to people being out because they are having to take care of their kids, the federal FMLA expansion could apply. Regular FMLA still applies. So to the extent that there's a serious health condition, the emergency provisions apply immediately, and they would apply potentially to the first 2 weeks that an employee is out. So as you can probably surmise from that description, there's a lot to consider here, and unfortunately, it's one of those things where it's going to be a case-by-case analysis. You got to think about what exactly we know about the employee, and through that, go through each of the potentially applicable laws, the policies in your handbook. If you are in a collective bargaining environment, you're going to want to look at provisions in your CBA. And as Greg has said a number of times, we want to try to do the right thing by employees. This is a difficult time, but we also want to make sure that we understand this area of the law. It's changing a lot. There's a lot of different levels of analysis, and so with respect to each request for sick leave, we want to make sure that we're applying the right benefits based on the right facts. Greg, did you have anything you wanted to add to that?
Nope, I think that's great. I think that's right on the money. Okay. This was a question that came up before we gave the presentation. People gave us some questions. Question, what obligation to pay if the dealership must close to disinfect the premises? Good question. It depends on the type of employee. If it's a regular hourly employee who is non-exempt, meaning that they're not entitled to overtime, if that's the case, then and you have to close for a day or two, then you don't have to pay him or her because they're not working. There's no rule that says you can't pay them, but you certainly don't have to pay them. So that's the rule for non-exempt employees. If they are an exempt employee, meaning they don't have a right to overtime if they work more than 40 hours in a week, then you will have to pay them unless the cleaning process takes more than a week, which probably won't. So that's how you would treat the exempt employees. The union obligations, again, as Sarah and I have been saying, you have to look to your collective bargaining agreement and hopefully you have good relations with your unions so that you might implement these in a non antagonistic way. But it depends on what your contract says. That's the starting point for any analysis relating to the unionized folk. Let's see what else we got here. Updating your policies. This question has come up a few times. And it's kind of like a natural human resources question. Human resources personnel always are asking, oh, do we have to update the handbook? Do we need a new poster? What should we send out a memo to employees? Here's my best advice. The answer is no, not for the moment. The difficulty that exists right now is that these laws are in flux. They're changing. As you see from our presentation, I mean, just this week we had one executive order on Tuesday and a new one on Wednesday. The federal law doesn't take effect, we don't think, until April 2nd. And we're promised that there's going to be some guidance. So, if you were going to make a policy, you'd want to put in that guidance. Or you might want to. We just don't know what it's going to be. So right now we're advising employers, hold off, don't worry about updating your policies for the moment. The only caveat I'd say to that is that the federal law, excuse me, not the federal law, the state executive order did say that they were going to issue a, I'm sorry, I messed up. It's not the, I think it's the, and Sarah, correct me if I'm wrong, I think it's the state leave law said that they were going to issue a poster. So we may have a poster. If there is a poster, we'll let you know on any of these laws. They always love to give you a poster when one of these things come up. But right now, don't worry about the policies. Frankly, don't even worry about the posters. They'll be coming and you'll get alerts on that. But right now, there is no poster. There is no reason, we think, or no good reason to update your handbooks or your policies. Just so hold off. I turn it to you, Sarah.
Great. And so, Greg, I'll mention that I'm just realizing that people are able to send us chats while we're presenting. And from those chats, I've learned that apparently the governor just announced all non-essential employees in the state have to stay home.
So they changed them. It sounds like we're only hearing this secondhand, but it sounds like they're changing the rules while we're talking.
Right. So I think that the test drive issue is perhaps not timely anymore, although we were glad to share this graphic with people. We do think if it does become relevant, again, based on the CDC's recommendations for social distancing, we should not be requiring employees to take customers on test drives. I understand. My dad's a car salesman, so I understand that that's difficult because that's why people go to car dealerships. And hopefully these restrictions will not be for very long, but for right now, test drives would probably fall within the non-essential function of a dealership. And so that's just not going to be able to be part of our business for the time being.
Okay. A few other considerations briefly, because we're running out of time here. Warn notices, if you're going to close your whole shop or your business, there's obligations under both federal and state law to give advance notice. And under the federal law, you're supposed to give 60 days notice. Obviously, these are exigent circumstances. You don't have to give 60 days notice. You don't have to give any notice at this point, although you should give out the warn notice and explain that you're closing your shop under these exigent circumstances. You only got the executive order saying that you had to reduce or eliminate staff. Your customers are down. Your business is basically suspended. But so you don't have to send out the 60-day notice, but you do have to, if you're closing shop, you do have an obligation to send out warn notices, and those notices should explain the fact that you're closing because of exigent circumstances, not because of any other reason. There's rules about what you should do. OSHA has some, doesn't have any specific rules on the coronavirus or COVID-19, but what we've been advising clients is follow what the CDC says. Rehire issues, I kind of briefly touched on this. If you terminate people or lay them off, just be aware that you want to, someday you may want to rehire them. There's questions, and I don't know the answer at the moment. We have to see what law comes out or guidance comes out. But there's questions about, do I have to get I-9s again? Do I have to, get them ramped up again with filling out all these these forms, including the Wage Theft Prevention Act notice in New York. Don't know the answer yet. We will have answers for that. My gut reaction is if it's a short layoff, I wouldn't necessarily think you'd have to do those things. Benefit issues, quickly, obviously part of this, when you terminate somebody or you have to reduce their work, you may have benefit issues, especially with health insurance. Go to your policy, go to your carrier, make sure your employees can have continued benefits to the extent that's possible and consistent with your contracts. Also, just be cognizant if the business is down, if people have 401ks that they may be feeling the pain, you may want to explain to them that they should talk to your plan administrator if they have benefit issues related to that. But that's some of the other potential considerations. There's a lot. I know we covered a lot, and we appreciate your time. If you have further questions, reach out to either Sarah or me or your favorite bond attorney. Oh, the takeaways. We have one more slide. Thank you, Sarah. The takeaways, I think, and Sarah can chime in, I think that the biggest takeaway is that employers should try to do their best under these difficult circumstances to treat people with kindness and respect, and we will persevere together.
Yeah, I think that's a great note to end on. And thank you everyone for your time. I do think that there is a way that we can, we'll be able to read some of your questions after the presentation. So I'll work with Greg and the bond team to see, if we can continue to assist any of you in the future as things unfold, but hang in there.
Yep, thank you all.